Judgment. You already know what is judgment. Judgment is the final conclusion of a case. So judgment is very wide concept that is applied by everyone on a daily basis. A human being is engaged in different circumstances throughout the day that requires the ability to pass a proper judgment. Therefore, it can be included as a fundamental part of human thought process. So in the case of Surendra Singh versus State of UP, AIR 1954 SCR 330, the Supreme Court defined the term final verdict or final decision given by a court to the parties delivered in the open court by pronouncing it. So the meaning of the word judgment is, please underline, the final verdict or the final decision given by the court to the parties and delivered in the court, open court, by pronouncing it. I am giving you one work. You have to find out the difference between verdict, order and judgment. Okay, please make a note somewhere. Verdict, order and judgment, the difference between the three. Now next is judgment, section 392. So the judgment in every trial in criminal court or the original jurisdiction shall be pronounced in open court. Please underline the word open court, by the presiding officer immediately after the termination of the trial or at subsequent time not later than 40 days from the date of notice shall be given to the parties or their advocates. Please underline, not later than 40 days of which notice has to be given to the parties and their advocates. So by delivering or whole of the judgment, by reading out the whole of the judgment, by reading out the operative part of the judgment, please underline, by reading out the operative part of the judgment and explaining the substance of the judgment in the language which is understood by the accused or his advocate. For example, if you are pronouncing the judgment in English but the accused or the lawyer does not know the English language, so in that case you have to even brief them about in Hindi. So where the judgment is delivered under subclause A of section 1, the presiding officer shall cause to be given down in shorthand, sign the transcript and every page thereof as soon as it is made ready, and write on it the date of delivery of judgment in the open court. So after that the judge has to sign in each and every page, and he have to also give the date on which he delivered the judgment in the open court. Now where the judgment or the operative part of the judgment is read out under clause B or the clause C of subsection 1 as the case may be, it shall be dated and signed by the presiding officer in open court, and if it is not written in his own hand, then every page of the judgment shall be signed by him. Before, judges used to write judgments in their own handwriting, but now they type it and on every page they sign the judgment stating that this judgment is delivered by them. Now where the judgment is pronounced in the manner specified under clause C of subsection 1, the whole judgment or a copy thereof shall immediately be made available for the perusal of the parties or their advocates free of cost, provided that the court shall, as far as practicable, upload the copy of judgment on the portal within a period of 7 days from the judgment. So if it is okay for the court, they can even upload the judgment on the website. Now if the accused is in custody, he shall be brought to hear the judgment pronounced either in person or through video, audio, electronic means. So the judgment will only be delivered in presence of the accused person. Okay, on the day of judgment he must be present. If he is in jail, he has to be brought from jail. If he is not in a situation to be brought, then audio video means he should be present. Now if the accused person is not in custody, he shall be required by the court to attend the hearing when the judgment is pronounced, except where his personal attendance during the trial has been dispensed with and the sentence is only with fine, when he is acquitted, then his personal attendance is not required. In the case of Elchuri Manohar versus State of Andhra Pradesh, it was held that the electronic media cannot give any leading element or part. Now what are the purpose of the judgment? Purpose of the judgment is to determine whether the person is guilty or innocent. So after considering all the facts, evidences and laws, the court will take the final decision in a particular matter to set the position of the individual person, whether he is guilty or whether he is innocent. For determining the rights and liabilities of the parties, determination of rights and liabilities is the main work of the court to come to an end. So for development of legal jurisprudence, so where the court has heard all the facts and evidences from both the sides, certain principles can be introduced which affect the matter and help in development of laws in various fields. For example, Dono versus Stevenson case introduced the concept of law of negligence. So it serves, what will be the purpose? It serves as a precedent. So in common law, the doctrine of precedent depend upon good, relevant and honest judgment. In the future, these kind of cases are relied upon this jurisprudence. Then provide accountability to the judicial officers. So court of law is known as the temple for justice, and the judges are considered to be the god for giving justice. So there is always an eye on the work and credibility of the judges and magistrate. So delivering good judgments help the public trust the judiciary. The reason should be communicated to both the parties. So both the parties along with their lawyers must be communicated with the reasons on resulting judgment of the case. Even if they lose the case, they must be informed on what ground they lost the case. Proper communication should be maintained. So these are the purposes. Now we will look into section 393, language and the content of the judgment. So every judgment is recorded and written in a local language of the court prescribed by the state government. Point of determination shall be considered while making the final verdict. So it should clearly include, underline, important evidences, details relating the offence committed by the accused person, laws under which the act falls, which help to conclude the trial and the judgment. So if any uncertainties between the two parts of the same sections for the offence, then the court should specify according to them and pass judgment. If the punishment is death penalty or life imprisonment, then the court is duty bound to furnish the reason why they are giving death penalty or life imprisonment. In the case of Rambali versus State of Uttar Pradesh, it was observed that the language and content must also be self-contained, and it must reflect that the court has applied evidences and facts while forming the judgment. So in judgment you will see that it includes every aspect. Okay. Yeah. Next, order for section 394, order for notifying the address of previously convicted offenders. So if an order is given by the judicial officer is appealed and there it is set aside, then it will be declared as null and will be not applicable on future judgments. Okay. So for example, the trial court has convicted, but in appeal it was set aside, and then the judgment of the trial court will be declared as void and it will not act as applicable to the future judgments. Now section 395, order to pay compensation. So when a court imposes a sentence or fine, then while passing the judgment, the court can also order to recover the whole or part of an account, calculating the whole expenses that are incurred in the prosecution process. So this is also a process that is followed by the court to order for payment of compensation. Okay. Hello? Any doubt? If possible, I will share with you one sample of judgment, how the court. Yeah, so this is just the first and last page of the judgment. You can see here that date of the offence will be mentioned, date of FIR, date of charge sheet, date of framing of charges. Okay, so all these things will be mentioned, and after that it will be also date of commencement of evidence, then date of judgment is reserved. So date of judgment will also be written. After that, when you will see order, here it is ordered. So let the accused be leveled against him and the case giving him a benefit of doubt. The bail bond filed on his behalf will remain in force for 6 months. The judgment is sealed, signed and pronounced in open court. The word open court we read so many times. in presence of the learned defense counsel and learned special PP, then it will always have the sign of the judges.